For those of you who have practiced in the civil criminal division of Oakland County, you have probably already been involved in e-filing, because we've had e-filing for, I don't know, about 3 years, something like that. And it only initially will apply to divorce cases without minor children. The initial filing will have to be paper because you won't know which judge you're getting until you actually file and there's an assignment. But if you are doing pro bono work or legal aid, you will be given a special passcode so that you can do your filings without paying any additional fee. So you need to make sure that you go to the training and get all the information. You will also be serving by e-filing. But if you have questions, Lisa Chiz is the person in the case assignment office that will help you. You can call her. You can go to our website. There's information. There is a specific administrative order that the Supreme Court approved with respect to the operation of our e-filing project, and that's available. It's linked on the website, so you can see that as well. Court Explorer is actually the county clerk's project because they're the keeper of the records. So Court Explorer has been up now, I think, about 5 years, maybe, something like that. You may see the Register of Actions simply by going to the Court Explorer website and putting in a party name or the case number. And then you can see the Register of Actions, and it will tell you, you'll see there's a little difference in color, where there is a document that has been filed. Not everything on the Register of Actions is a document. Sometimes it just records something that happened. A motion was heard, for example. So there may not be a document. But you can see what the history of the case has been. You can see when something is scheduled for a trial, because it's going to be in the Register of Actions. You can order a copy of a document. You must pay for it. It's $1 a page, but you can pay for it with a credit card, and it is emailed to you within a matter of hours. It's very convenient. If you're also representing somebody, maybe it's not pro bono, but it's maybe it's through legal aid or in some other way where they don't have funds, and you are not getting paid, then you can file a request for a waiver of fees. We see this all the time with pro per litigants. They come in and they request a waiver of fees in circumstances where a person is indigent, unemployed, very, very low income, that sort of thing. On motion day, I really don't want anybody to leave the courtroom without having drafted the order or presented an order for what happened moments ago. Now I do, and you'll hear me say this, I do want the attorney with the best penmanship to write the order because some of them are almost impossible to read. But you can handwrite an order. If you're really on top of things, you will have prepared a couple different versions of an order and bring that with you. But I don't like you to leave unless you have an order entered on whatever happened in the motion. That's not for your personal use, just any old time, but if you're there for a hearing and maybe we haven't been able to establish the other party's income until just then because he or she didn't bring any information to the friend of the court, we can run the guidelines right then. And on our motion day, we do have friend of the court personnel in the building, those personnel that are assigned to each judge, and they also can run the guidelines. So usually if you have a motion for modification of child support, for example, you go see the referee will run the guidelines and write out a recommendation that includes the calculation, so that when you come into the courtroom, which you would do right after you see the referee, I have that recommendation with the calculation. Now, my courtroom and now more than half of the courtrooms in the building are outfitted with a digital recording system. I think it's an extremely helpful tool for lawyers because you do not have to wait and order a transcript to find out what I said last week. You can request a copy of the DVD. If you come back and you're arguing over an order or a judgment, honestly, I'm pretty good at remembering things, but I don't remember everything I said, so you've got to show me what I said. And that's a real easy way to do it in Oakland County. Just a couple quick ones, and that is When you present your proofs on a divorce case, now, this is, I don't know why it's so difficult, but the question is always, were there any children born of this marriage? And the woman will say no. And then I'll say, do you have any children? Yes, I have 4. Well, when were they born? Oh, they were born after he left. So they were still married, there's 4 children, they're not his kids. We have to deal with that. As lawyers representing the plaintiff, when the parties come in, or the plaintiff comes in for the first interview, ask some really delving questions into children, because you don't want to be surprised. I've had some lawyers whose eyes have nearly popped out of their head when they get some of this information on the record and they think they're entering a judgment. Be really careful. In this day and age, there's lots of kids born, not of the marriage, but during the marriage. The comment about vacation notice to the case manager, we set all the trial dates in the courtroom with everybody present. So I'm going to set a date. I'm going to ask you, are you available May 17th? And if you tell me yes, then I'm going to expect you to be there. I'm giving you a chance to look at your calendar and decide whether or not that's a good day or not. If you tell me no, I'm going to be on vacation, then we'll pick another day. That's one of several reasons why we want the clients there. They can see their attorneys at work, and I do often introduce the lawyers to each other for the first time at the settlement conference, and just being there often resolves the case. So I think there's a lot of good reasons, and that's why Oakland requires the presence of the litigants. Now, we mentioned Judge Online, and Judge Online has been in effect now for a couple of years, although the court rule has been in effect since, I think, about 83 or 84, that permits the use of electronic equipment, maybe it says telephonic equipment, to allow parties to appear. And this is simply a program that has encompassed that particular court rule's permission. We've just sort of done it circuit-wide. And it doesn't apply just to the litigants, it can apply to the lawyers too. If, for example, you are stuck in Macomb County, that would never happen, but, and you are also supposed to be in front of me on a settlement conference, for example, and your client's in the courtroom waiting for you, you can call in. And you can make arrangements then to have your appearance by phone. So you can utilize Judge Online, I think, very effectively to save you time and to save your clients time and expense if it means traveling from one place to another. Last thing I'll mention is that we do have a duty judge procedure in Oakland County. If a judge is not in, like I'm not today, there is a judge assigned for the week to handle matters that come up in front of a judge who's not present. So if one of you were to file a complaint and you wanted ex parte orders signed, you would take those orders to my office. My clerk would review them and initial them. If they were orders I would sign, and then you could take them immediately to the duty judge's office and get the orders signed. So we've tried to take into account when judges are absent.